adjourning the debate at 8 o'clock.
I welcome the opportunity to contribute to this important debate, and it's a very important piece of legislation. It is all this evening on behalf of the Labour Party to say that we are unambiguously and unequivocally in support of the early implementation of this legislation. We are all aware of the purpose of the objectives behind the Civil Registration Bill 2019, which is to bring forward a number of amendments which are extremely technical in nature, and I want to concur with what Deputy O'D says. You know, legislation, and it's extremely difficult for ordinary people to interpret or comprehend. And I can tell you, I spent a few hours trying to read this today, and I was baffled by some of it. And so, you know, you just place yourself in the seat or steps of an ordinary individual who's not has no lawyerly intonation at all. And it's essentially amended the Registration Act 2004. And I recall I expended a considerable amount of time down in the bunker in relation to debating that. I'll never forget it. It was an intrinsically complex piece of legislation, and we were hardly out of the bunker when it had to be amended again. And therefore, it is no surprise in the context of further advancements in law and science, and it now requires further amendment in the context of our evolving society, the diversity of family formations and family types and relationships and everything else. In brief, the bill makes a number of amendments to civil registration in relation to the registration of donor-assisted births, the presumption of paternity when registering births. It expands the role of next of kin in registering a death in cases where the coroner is involved. But I concur a bit with Deputy O'D in that. That doesn't seem as expansive as it sounds. It permits the sharing of the General Register Office's historical data and records with the National Library, the National Archives and the Ministry of Culture, and it facilitates collection of additional details in respect to deceased persons so that the CSO can comply with the obligations arising of the EU obligations. Of course, that pertains to Eurostat, furnishing the statistics and that. Well, the bill is relatively short. It is significant in impact and import, and it is of huge importance to the families that are affected, Minister. And like everybody else, we have been contacted by a huge number of people, myself and my Labour Party colleagues over the past number of years, because we were certainly at the vanguard of promoting this legislation over the years. The errors, the bill corrects an error, and essentially what happened was that the two acts passed in 2015, the Gender Recognition Act and the Child and Family Relations Act. Both acts made amendments to the Civil Registration Act 2004 by a certain additional definitions into Section 2 of that Act. And the Child and Family Relations Act inserted the following, and this is what I have to follow up now. The Act of 2015 means the Children and Family Relationships Act 2015. Donor-conceived child has the same meaning as it had in Part 2 of the Act of 2015. Parenting in relation to a donor-conceived child means the parent or parents of that child under Section 5 of the Act of 2015. Now listen to this. The Gender Recognition Act inserted the following. Act of 2015 means the Gender Recognition Act 2015. Gender Recognition Certificate has the meaning assigned to it by the Act of 2015. So it was all, cross purposes. There's no wonder. That was part of the delay. And of course the part of the ambivalence in terms of legislation and trying to go through it. So we ended up with two acts of 2015 referred to. And because of the impossibility of interpreting legislation properly, the relevant parts of the Child and Family Relations Act could not be commenced. The change therefore facilitates the commencement of legislation that provides for the registration and registration of births of donor-conceived children. But it's a long time awaiting, and a massive error was made. The bill amends the reference to Section 2 of the Civil Registration Act 2004 to the Child and Family Relations Act 2015 as the Act of 2015 and refers instead to that Act by its full name, and that gets rid of the problem. The technical amendment facilitates commencement of existing legislation to allow both partners in either a male, female or same-sex female relationship who have been through a donor-assisted birth process to have their details shown on birth certificates. The result will be that the gestational mother will be listed as mother on a child's birth certificate, while a second female parent can be registered as a parent. Note that when the 2015 Act provides for either a man or a woman to be the second parent of a donor-conceived child, there must be a birth mother. So the Act does not apply where two men seek to be registered as parents of a child, of which one is the birth father. Same-sex male relationships are still excluded, since under the 2015 Act, in every case of donor-assisted human reproduction, the birth mother is always a parent of the child. So a male couple may well have to go down the adoption route to deal with this issue. So that's now the evidential value of birth certificates. Now this is just a little hobby horse of mine, Minister, so don't mind me going off on this. It may be worth noting that passing all of these amendments to the law are based on the notion that the birth certificate actually proves the relationship to which they relate. As a matter of strict law, they are not, in fact, of no evidential value in terms of proving age, identity or parentage. Most of us rely instead on the presumption of paternity, that a husband who is living with his wife for 10 months before she gave birth is the father of the child, or, if necessary, a DNA test in order to establish paternity. But in criminal law, the rules of evidence have been changed so as to make a birth certificate admissible in evidence. Section 5, subsection 5 of the Criminal Evidence Act 1992 provides that where a document purports to be a birth certificate issued pursuant to law, and a person is named therein as a father or mother of the person to whose birth the certificate relates, that the document is admissible in any criminal proceedings as evidence of the relationship indicated therein. And I think we should take an opportunity to do the same, to reform the civil law along the same lines and make sure that the birth certificate is, that presumption is and is admissible in any civil proceedings. The bill seeks to amend existing legislation to allow a mother to more easily rebut the presumption of paternity of her estranged husband and registered at birth by filing a statutory declaration. And this is certainly a welcome amendment, Minister, particularly in relation to where there has been, shall we say, a very difficult relationship, or where totally estranged and maybe violence attached to it, or whatever else this is. And it makes it less onerous on the mother to rebut the presumption, which in fact is automatic in nature, of course, in terms of the paternity of the child being registered. The bill seeks to provide a role for next of kin and registered death in case involving a coroner. And according to the expanded memorandum, and that's the only thing I could figure out, was that the relevant section provides for the inclusion of family members of qualified informant in the registration of a death where a coroner is involved. And this will allow the family deceased to have a greater role in the registration process, which in some cases may result in the registration of a more complete set of particulars, and that's useful. And then the collection of additional minutes. So all in all, Minister, I think the Labour Party unequivocally welcomes and supports the quick passage of this legislation for people affected. They want it passed yesterday, so there should be no more unnecessary delay. And like my colleagues, Minister, I had a call there from two people yesterday about this bill, and the text of the bill is fine from most people's perspective in terms of recognising same-sex parents on official documentation. But everybody's concern relates to timing. How quickly can this legislation be enacted and implemented? And, this is an issue that has affected same-sex parents for a number of years now, and, Minister, you can understand that people affected are anxious to see the amendments implemented. And, Minister, I was asked from a number of organisations who have been in contact with myself and my Labour Party colleagues, could you give an indicative date for when the legislation will complete all stages in the Oireachtas and be enacted? And will there be a gap of time between enactment and commencement, which is the critical thing? Because it's the commencement that kills the whole thing dead. We might work very well, and Minister, you're working well to get this through, and I'm sure you'll be facilitated in the Senate. But we need an indicative date for when the legislation will actually come into effect. I know that some of the revisions depends on the commencement of specific parts of the Children and Family Law Relationship Act 2015, namely parts 2, 3 and 9, which have been referred to extensively here by my colleagues. And since the responsibility for commencement of that lies with your colleague, the Minister of Health, I would hope that there will be no procrastination or undue delay on his behalf or under his stewardship or superior suspension. So I think that's important, Minister, that you'll be in a position to give us unambiguous or unqualified replies in relation to when it's going to be commenced.